turned off or on silent and is not permitted to be used in the courtroom unless permission is given by the judge. Are we ready to proceed?
Yes, ma'am.
Yes, thank you.
Right back. All rise. Court is now in session. Good morning. You can be seated. All right, it's Tuesday, April 15th, 2025. I'm Judge Paschke. We're on the record on case number 25C31, matter known as State of Ohio versus Devin A. Hernandez. We have Mr. Hernandez with us via video from the Geauga County Jail. Good morning, Mr. Hernandez.
Good morning.
Mr. Hernandez, you do have the right to be physically present here at the court for your hearing today, or you can, if you choose, go forward via video like we are this morning. Are you consenting to going forward via video?
Yes.
Okay. If something comes up during the course of the hearing and you need to speak privately to your attorney, you let me know and we'll take a break and give you a chance to speak privately to your attorney, okay?
Okay.
All right. Then we have Mr. Clammer here in the courtroom today. Good morning. He is representing Mr. Hernandez, and we have Mr. Flays, the Geauga County prosecutor, here on behalf of the state of Ohio. We also have the victim advocate here in the courtroom, and we have Ms. Bokar from our court's probation department with us via video from the probation department's offices. Mr. Flays, will you introduce the case, please?
Thank you, Your Honor. The defendant was originally charged via complaint with Chardon Municipal Court, and while that matter was pending, the case was presented to the grand jury, and there was an indictment filed on April 11th of this year, and then I believe the paperwork was sent over from municipal court yesterday, and I'm seeing the waiver over there, so we are here for an initial appearance and arraignment. Thank you.
All right, thank you. Mr. Hernandez, have you received a copy of the indictment?
Yes.
All right. Mr. Clammer, on behalf of Mr. Hernandez, do you waive any irregularities as to time and place of service?
Judge, only a few irregularities I can waive are those, just by way of the record, the indictment charges the sexual activity version of 290703. My initial research indicates that that was not the version of the statute in effect at the time charged in the indictments. Obviously, we'll have to litigate that issue, but as far as any waiver, I need to make sure I preserve that one. Thank you.
And do you waive a formal reading of the indictment?
As long as I preserve that issue. Thank you.
Understood. Okay. All right. So, Mr. Hernandez, your attorney has waived a formal reading of the indictment, which means I'm not going to read it to you word for word. I do want to go over the maximum possible penalties with you. It is a 6-count indictment. Each count is sexual battery and a third-degree felony. If convicted, each of those counts could carry with them a possible prison sentence of 12 to a maximum of 60 months, a maximum possible fine of up to $10,000. There would be, if there was a prison sentence, there would be 5 years of post-release control that would be required, and you would be required to register as a Tier 3 sex offender. That would be every 90 days for life, and you would not be permitted to live within 1,000 yards of a school or daycare. Counsel, did I recite those maximum possible penalties correctly?
Yes, Your Honor.
Yes?
I believe yes, Your Honor.
Okay. All right. Do you understand those maximum possible penalties, Mr. Hernandez?
Yes.
Okay. All right, now I'm going to go over your constitutional rights with you. You have the right to counsel. You have the right for reasonable continuance to obtain counsel. If you cannot afford counsel, counsel will be provided for you at the state's expense. You have the right to remain silent, the right to a jury trial, and the right to reasonable bail. Do you understand these rights?
Yes.
Okay. And Mr. Clammer, I believe you filed a notice of appearance of counsel. Is that
I
correct?
did file the notice of appearance. I also signed your court's form. I have that here in front of me.
Okay. All right. Thank you. I'm going to ask my bailiff, Ms. Trent, to collect the forms from you.
Yeah, I have the authorization that I signed for my client for the text message, my notice of appearance, and then a waiver and request to enter a plea, enter not guilty, and I signed for client.
Okay.
Thank you, Judge.
All right. Thank you. Thank you. All right, so I do have Mr. Clammer's notice of appearance. Then, Mr. Hernandez, I know that you did this with your attorney either over the phone or over video, but he signed on your behalf that you're consenting to receive text message notifications of court hearings. You're in agreement with that, correct?
Yes.
Okay. And then he also marked on here this form, which is a waiver and request to enter plea. Again, I believe your attorney signed this with your phone consent. This document indicates you understand you can not be called upon to enter a plea at your initial appearance, which this is your initial appearance here for this case. However, you're going to waive a separate arraignment and ask the court to enter a plea of not guilty at this time. Is that correct?
Yes.
Okay.
I'll just clarify, it wasn't with phone consent. He was just arrested yesterday, but I believe I have the authority. I think you clarified.
Okay.
Thank you.
Okay. All right. With that clarification, you're still in agreement with that, correct?
Yes.
Oh, okay. All right. Then the court will accept your plea of not guilty, and we're going to assign a judge to your case.
This case is assigned to Judge Carolyn J. Paschke.
All right. Your case was assigned to me, which means your future hearings will be here in my courtroom. I'm located on the first floor of the Geauga County Courthouse.
Yes.
All right. All right. The address that I have for you is 1412 Summit Drive, Mayfield Heights, Ohio 44124. Is that a current address?
Yes.
And how long have you lived at that address?
Since June of 2022.
And who do you live there with?
My wife and son.
All right. And I usually ask about employment, but it's my understanding that some of these allegations involve things that may have occurred during your employment. So I think I'm gonna leave that out for today. Do you have any prior felony convictions?
No.
How about any misdemeanors with the exception of a minor traffic offense?
No.
Are you aware of any outstanding warrants for your arrest?
No.
And have you ever failed to appear for a court hearing?
No.
All right. Mr. Flays, is this consistent with the information that you have?
It is, Your Honor.
And does the state have a recommendation regarding bond?
Yes, thank you, Your Honor. The state is recommending $20,000 cash or surety. I believe there was a surety bond posted in municipal court that should have been transferred over yesterday. The state is asking for the standard conditions with some additional conditions. The state would request that the court order no contact with the Hawken campus, no contact with the NDCL campus, no contact with any unrelated juveniles, no contact with the victim, no contact with the victim's family, and no contact with the victim's places of residence. It'd both be her home here in Geauga County and her residence at school. The state is also asking that no contact with the defendant, no contact with the victim by the defendant or through any third parties. And I know the state, I haven't spoken to the victim regarding this matter, but the victim advocate is here. She did speak to the victim. Victims do have both constitutional rights and statutory rights. The victim did express that she did not want to be contacted by defense counsel or any investigators working on behalf of defense counsel, and certainly does not want defense counsel's investigator knocking on her dorm room down at college. So we are asking the court to prohibit any contact by the defendant or through any third parties. Thank you.
All right, thank you. Mr. Clammer, do you wish to be heard regarding bond?
Yes, Your Honor, thank you. Your Honor, that was the bond that was posted. I assume it made it over to you, so we agree that that bond can go ahead and be continued. If you have any questions about whether that's appropriate, I would just tell you he is unemployed. You know already about his record. He's here with his wife who's pregnant, and I want to say about 6 months. She has a humble job, so anything they had to scrape together for purposes of the bond, they've already scraped together. He's appeared at both of his preliminary hearing dates, one that was continued and we mistakenly appeared, so he appeared there. He appeared voluntarily yesterday at another preliminary hearing date and was arrested outside the courthouse. He would have turned himself in had somebody just issued a summons. We would have walked ourselves down to the jail. But we think that $20,000 is appropriate. As far as not being at the Hawken campus or the NDCL campus, he won't be there, of course. I think you understand where his wife works, so she'll, of course, be at NDCL campus. As far as, I assume we reference unrelated children. I assume that means children not related to the defendant. So if that's the case, we understand that. You know, we had this, I think this debate last time on Mr. Serino's case with regards to the defense having the ability to contact any witness that they want. I think we did end up litigating that upstairs in front of Judge Andre, and he ultimately at some point did, I think, remove that condition. Your Honor, I hate to do this. I hate to imply any wickedness on behalf of the state, but they can't do anything to interfere with our ability to contact any witness, including an alleged victim or alleged victim's family. They can't suggest to them. They can't disparage the defense or disparage a defense investigator. They're not allowed to do any of those things because that interferes with our ability to investigate this case. We already think there may be a defect in the indictment itself, as we think it charges the wrong statute in effect. There's going to be a question of sexual activity versus sexual conduct versus sexual contact. All of those things are critical. The alleged victim in this case is an adult. We know that some of her family members, at least at this point in time, are important witnesses to the defense as they have contacted the defendant on their own. So we just think that that's an incredible overreach. To a certain degree, I dare I say, I tolerated it on the Serino case, knowing that Your Honor asked me to, and that I could work with the victim's advocate, who's always a pleasure to work with. But ultimately, we had to ask the judge to remove that because the prosecutor, even upstairs, protested our ability to contact the victim, and he ultimately did rule along with the defense. So I think any indication that obviously the defendant or his family isn't going to go contact the victim or the alleged victim or the alleged victim's family, but the defense investigators, all those people have every right to do it. And to the extent that the state has, or any representative of the state has suggested that our efforts to do that are somehow improper, I trust they'll correct that and indicate to the alleged victim that we have every right to continue to investigate the matter. So other than that, I think that the condition should be removed.
Mr. Flazy, you wish to be heard?
Just briefly, Your Honor. Again, the state doesn't like to litigate matters at initial appearances, so the state would request that bond condition be put on and that motions be filed and the court look at, the Marcy's Law constitutional amendment that was codified, that took effect just 2 years ago. It is an evolving issue, and victim rights have been recognized. While defense counsel seemingly making a lot of accusations, again, myself and none of my assistant prosecutors have spoken to the victim regarding this matter, and actually the statute put some requirements upon us regarding victim interviews. So we will be following the statutory scheme. However, for purposes of today, I would ask that the court impose that and then allow the parties to, through motion practice, flesh those issues out. Thank you.
All right. All right, here's what we're going to do. I will address that issue. I will follow the recommendation that the bond be set, in this case, at $20,000 cash or surety. I believe we're not continuing the bond because this is a direct indictment, is that? It's a little bit of a legal limbo there, right?
Your Honor, I would be okay, just from it is a legal limbo. That's a good way of putting it. The bond did transfer over from municipal court, so the case should have transferred over, and they should have transferred the surety bond over with the docket. That's what it looked like when I checked the docket this morning, was that municipal court had sent everything over. And if that's the case, the state has no objection. I mean, rather than returning that and then having another, I mean, that just seems like a waste of time and effort on everyone's part. So the state would be fine with the court ordering that the surety bond posted in municipal court be accepted and applied as bond in this case. I think that would be the easiest thing for everyone.
That's what I'll do. I'm going to set the bond at $20,000 cash or surety, and I'm writing on the bond form, surety bond from municipal court is accepted and applied to this case. I am going to, Mr. Hernandez, I am going to put in the no contact order. You are ordered not to have contact with the Hawken campus, with the NDCL campus, with juveniles not related to you, with the victim, with the victim's family, with the victim's places of residence. And when I say victim, I will correct myself and say the alleged victim. And as the issue of third parties, what I'm going to do is say that contact with third parties may be made subject to approval by the court. So we will address that in the future.
Thank you.
Okay. Then I'm going to give you the rest of our standard bond conditions. You're ordered not to possess or consume any alcohol, marijuana, THC, or drugs unless prescribed by an MD, a DO, or a dentist. You're ordered not to enter any bars or places where alcohol is served as a primary source of income. You're ordered to obey the laws of the state of Ohio and not leave the state of Ohio without permission from the court or the court's probation department. You're ordered to submit to random alcohol or drug testing by means of breath, blood, or urine sample. And those will be your bond conditions.
Okay.
Do you have any questions about those bond conditions, Mr. Hernandez?
No, I do not.
Okay.
Maybe I zoned out. Did you say pretrial release?
I did not order pretrial release.
Thank you.
Okay. All right, then they've taken care of fingerprints, photographs, and DNA. I believe that takes care of everything I need to address today. Mr. Flays, anything else on your end?
No, thank you, Your Honor.
Mr. Clammer, anything
I
else?
this motion on releasing my client's car. And when I got here today, there was a letter sitting on my desk, which I just assumed that Mr. Flays put in here. Is this meaning that the car can be released with new registration, Jim?
Your Honor, it's not an issue for the court. The letter's been presented. There's instructions in the letter, so I just don't think it's an issue for the court.
All right, Your Honor, just
So the state has no objection to the release of the car, is that what I'm hearing?
I don't believe the court should order it. The car is evidence. However, the investigator handling the matter has presented a letter releasing the car and providing instructions. The registration's expired, so they're gonna have to take care of that before the sheriff's office will release it.
just so that I'm clear, I can get my car as long as I follow this letter. Is that somewhat your same understanding, Judge?
Yes.
Thank you, Judge.
All right. All right, we're adjourned. Thank you.
Thank you, Your Honor.